All right. Good morning. You are Mr. Crusoe?
Yes, sir.
So you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On June 22nd, 2026, officer was patrolling when he observed the defendant's vehicle was stopped on a red light. The defendant's vehicle had a defective third brake light located on the center cab of the vehicle. The officer also observed an improper light color emitting from the defendant's brake light, displaying a yellow/white color due to a broken red lens cover. The officer initiated a traffic stop and made contact with the defendant and observed he had glassy, bloodshot eyes as well as slurred speech. The defendant was sweating and appeared fatigued/disheveled, consistent with signs of intoxication. When the defendant stepped out of the vehicle, the officer observed the defendant had an odor of alcoholic beverage emanating from his breath/person, and the defendant stated he had returned from his parents and had a few drinks, 2 glasses of red wine, and then changed his answer to 4 glasses throughout the day. State of sobriety test results are as follows: 2 out of 6 HGN, 7 out of 8 walk and turn, and 1 night stand was refused. Breath test was taken, with the results being 0.149 and 0.147.
When was the last DWI?
It was 2010.
And how many? And does he have a license?
Just that one. It was out of county. It was in Fayette. And then he has a possession of marijuana that was dismissed in 2018, and a possession of controlled substance that was dismissed in 2017.
Got it. Any, does he have a license to drive?
Yes.
That's eligible,
Let me double check it.
please. Mr. Crusoe, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. Because it's a second offense, I'm now placing an additional restriction. You're not allowed to drive any vehicle that doesn't have an interlock on it. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail. I will revoke your bond. This is not a revolving door. If I have to revoke your bond, into jail you go. No more PR bonds for you. I'm sending notice to DPS in Austin so that every police officer in the state knows if they pull you over and whatever car you're driving doesn't have an interlock, they will take you to jail.
He has an eligible license.
Great. You are not allowed to drive also unless you have valid liability insurance in your name. You must maintain car insurance. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Herman and he'll tell you if and when you have to come back to court. When I mean no alcohol, no illegal drugs as well. That includes marijuana. If I find that you test positive, then likewise you will go to jail. Do you understand these conditions? All right, I'm going to have you sign a reset. You'll get with Veronica for your bond conditions, and after that, we'll let you go. All right, please. Thanks.
All right, Judge Top 1, Abbas.
Good morning, Mr. Abbas. Sir, you're charged with a false alarm or report. You are facing up to a year in jail and or a $4,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 9th, 2026, officer was dispatched in regards to a suspicious vehicle. The officer made contact with a complaining witness who advised she was driving westbound on a white Ford Expedition. The defendant's vehicle cut her off in traffic, nearly causing a collision. The complaining witness stated she sounded her horn at the vehicle and the defendant brake checked her. The complaining witness advised that in an attempt to avoid further contact, she drove into a Walgreens parking lot, and the defendant then drove around the parking lot while yelling at her. The complaining witness remained on the phone with Harris County Sheriff's Office, providing the information on the defendant's vehicle. And when the officer arrived on scene, the complaining witness flagged down, advised the defendant had been yelling at her and possibly using racial slurs. The officer observed the defendant's vehicle to match the description provided by the complaining witness, and the defendant's vehicle was actively circling the parking lot. The officer conducted a detention. The defendant advised the complaining witness brake checked him and nearly caused a collision. When asked why the defendant remained in the parking lot, circling complaining witness and yelling, he stated he was testing the truck's suspension and was not concerned about the complaining witness. While the officer was speaking with the defendant, the complaining witness came into view. The defendant yelled, "You racist black bitch, your mom should have swallowed you," continued shouting. And the officer then instructed the defendant to leave the property. The complaining witness was also advised to leave. The defendant then contacted Harris County Sheriff's Department to report in Walgreens a white Ford Expedition and a white Ford Fiesta, and advised that a black male was sent, flashed a weapon, and advised that he honked longer than necessary. When the officers answered the phone, the defendant stated, "Oh no, not you," and immediately disconnected himself. And the complainant witness provided video footage of the incident from Walgreens and determined that the defendant's account did not match or support the surveillance videos provided. Sorry, that was long.
No, I'm just, okay. Does Mr. Abbas have a license to drive?
Check.
Please. Mr. Abbas, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. Your order is not to drive unless you have a valid Texas driver license and liability insurance. Do you know if alcohol or any kind of dope played a part in this?
Let me check. His license is eligible. I'm
Okay.
checking the DIMs just to make sure to see if there's anything about.
Mr. Abbas, do you have the ability to hire a lawyer?
Yes.
We will give you time. I'm going to have you go sign a reset. After that, we'll have you take a seat in the jury box. We'll get your bond conditions. Once you sign them, at that point, you'll be free to go. Do not pick up any new cases. Don't endanger my town. Otherwise, I will put you in jail in a moment's notice. Do you understand? I'm not going to warn you again. All right, come on. So, just don't. You have the right to remain silent. Exercise it. You just need a lawyer, and a lawyer can help you out. Please.
I was saying you're on the file.
Okay, so we'll just no driving without a license and insurance, please.
Okay.
If you don't mind filing those.
All right, Judge, bottom of 4, Artsy.
All right, you are Mr. Barty?
Yes, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On June 21st, 2026, officer observed the defendant's vehicle in the parking lot of a public park after hours. The officer initiated a traffic stop and advised the defendant of the city ordinance and he acknowledged the violation. As the officer was speaking to the defendant, he detected an odor of marijuana, and the defendant had advised they had been smoking a blunt, and a blunt was located in the cup holder of the vehicle. The defendant also advised there was marijuana in his backpack and that he had a weapon. The defendant did not have a license to carry, and the officer located a blue backpack that contained marijuana, as the gun mentioned, which was a Glock 19 with 27 rounds inside the magazine.
So did you say he was driving?
He was in a vehicle in a parking lot of a public park that was closed. But let me make sure he was the driver. Yes, he was the driver.
Got it. Okay. Mr. Barty, I'm going to find that there's probable cause to go forward with your case. Does he have a license to drive? As a condition of your bond, while this case is open, you are not to be in possession of any weapons. This includes guns, ammunition. Do you understand? If you violate these conditions, you pick up a new case, I will put you in jail. There will be no more PR bonds for you, sir.
He has a driver's license.
Got it.
So conditions, just no weapons.
Yeah, no weapons, please. No driving with a license, insurance. Do you have the ability to hire a lawyer?
No.
What do you do for a living?
I want anywhere else.
Okay. Do you have steady income? Are you working every?
I asked again. Yes.
No, but you're working full time.
Yes, sir.
Okay. I can have you fill out an application. I don't know whether you're going to qualify. We don't just give them out like it's candy on Halloween. You have to qualify, meaning that you're at the federal poverty guideline. So we will give you an application. I need to know how much money you have coming in on a monthly basis. I need to know where you live, what kind of cars you have, who else has an income as part of your household, and then I'll take a look to see whether you qualify. If you put zeros, I'm just going to send it right back to you. So fill it out and be honest because you're going to swear to it. All right, please.
Right.
Judge, page 5, Bello.
Okay, good morning, Mr. Bello. Sir, you're charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. It looks like you're also charged with interference with the emergency request for assistance. On that one, you're also facing up to a year. Okay.
Officer was dispatched to an assault call at a restaurant on February 9th, 2020. The complainant witness stated the defendant was causing a disturbance at the restaurant she manages. The complainant witness stepped outside and called the police. The defendant followed her and struck her in the left side of the face, causing pain. The defendant then took the complainant witness's cell phone, disconnecting her 911 call.
So this was at a restaurant?
Yes, it was the Frio Grill.
Okay. And you're saying he was managing the restaurant?
It looks like, well, I did speak to her and I believe she
Or
was.
she was managing?
She was with her general manager, but she was an employee of the restaurant.
Okay.
But the
Got
name
it.
says she was a manager, so.
Did alcohol play a factor?
Yes, it looks like she informed me the defendant was intoxicated due to bottomless mimosa.
Thank you.
Sorry.
That's right. Mr. Bello, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be tested. If I find that you're using, and I don't care what the occasion is, you will go to jail. There'll be no more PR bonds for you. Do you understand? You are not to have any contact with the complaining witness in this case and not to go back to this restaurant. Don't worry about filing conditions because I'm going to have him monitored for the alcohol. You're also ordered not to be in possession of any weapons and not to consume illegal drugs, including marijuana. You do, into jail you go. And on your case, you've got 2 cases. If I revoke your bond, you're going to be hitting, 4 or 5 digits. Do you understand? I'm not asking much, but I want my county safe, you endangered. I'm just going to go nuts on your bond. That's it. We're going to reset your case to give you time to hire a lawyer. I'm going to have you sign a reset. I'll have you take a seat while we wait for your bond conditions. Once you sign them, at that point, you'll be free to go. So please, that way, we need you to sign a reset first.
Judge TJ?
Yes.
Okay. Page 11, Hillary, come on up. We'll sign in just a second.
All right, Mr. Guillory, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On June 1st, 2026, officer was controlling and he observed the defendant's vehicle traveling on the road. The officer ran the defendant's license plate via TCIC and NCIC and observed he had an expired registration and a traffic stop was initiated. The officer observed the defendant had made furtive movements and leaned towards the passenger side of the vehicle. As the officer approached the vehicle from the passenger side, he talked to the defendant, who was the sole occupant of the vehicle, and observed an unholstered silver handgun sitting on the passenger seat in plain view, partially covered by a black sweater. The officer took custody of the gun and observed it had a fully loaded magazine.
What was the stop for?
The stop was for expired registration. And he does have an eligible driver's license.
Got it. All right. Mr. Guillory, I'm going to find that there's probable cause to go forward with your case. The only condition I'm placing on you is don't be in possession of any weapons while the case is open. You understand?
Yeah.
Do you have the ability to hire a lawyer?
Yes, sir.
We will give you time. I'm going to have you sign a reset. We'll have you take a seat in the jury box. We'll get your bond conditions. Once you sign them, at that point, you'll be free to go. Do not pick up any new cases. Do you understand? Yes or no?
Yes, sir.
Okay. Come on.
Sorry.
This way. What did you sign for your reset? Bottom of 13, Joan.
So you can file no weapons, please. Mr. Jones, this is the courtroom. This is a place that you go to. You have to dress properly. I don't wear shorts here. I'm not wearing pajamas. When you come back, please don't wear shorts. It's a complete sign of disrespect. Do you understand?
Yes, sir.
All right. You're charged with driving while your license is suspended. You're facing up to a 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On June 22nd, 2026, the officer observed the defendant's vehicle traveling on the 5701 block of Houston Road with expired registration. After initiating a traffic stop, the defendant could not provide proof of financial responsibility. A TCIC/NCIC check confirmed the defendant's driver's license was suspended effective March 6, 2026, and remains suspended. The defendant admitted that he knew his license was suspended.
Mr. Jones, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to drive. I don't care what you have to do in this life. There's nothing that you can justify getting into a car and driving. You will be signing an affidavit with me today. This is a promise that you're going to make to us that you're not going to drive. I don't care that you need groceries. I don't care that a kid has to go to the hospital. I don't care that you got to go to church. It don't matter. Do you understand? Do not drive. I will not warn you again. This is a promise you're making to me. If you do, I can have a contempt hearing. And every time you drive, I can hit you with 180 days in jail and a $500 fine. Do you understand?
Yes, sir.
The amount of people on our roads without insurance is absolutely bananas. And it's not fair if an accident takes place and they don't get to be made whole. It's not fair. You understand? We're going to reset your case to give you time to hire a lawyer. I'm going to have you swear to this. We'll have you sign a reset and we'll get you out of here.
Right.
So it's no driving.
Yeah, no driving.
All right, Judge, next is page 14. That's on.
I'm sorry, what was the last name, Victoria?
Top of 14.
All right, you are Mr. Catan.
Yes.
Sir, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On June 20th, 2026, an officer was working an extra job on Little Woodrose and attempted to trespass two defendants from the bar. Defendant/co-defendant were asked multiple times to leave and refused. While they attempted to escort the defendants from the bar, defendant Daniel threw a cup of water in the officer's face, and defendant Rolando, or defendant Katan, pushed back at the officer as he attempted to escort him out of the bar. The officer attempted to detain both defendants, with defendant Katan resisting arrest by pushing and stopping the officer from placing him in handcuffs, and the officer had to use force to handcuff him. Both defendants were very irate and aggressive towards the officer as they were being detained.
Got it. Sir, I'm going to find that there's probable cause to go forward with your case. You're ordered not to consume alcohol or illegal drugs and not to go back to this bar. If you do, I will revoke your bond and put you in jail. There will be no more PR bonds for you. Do you understand?
Yes, sir.
This is not a revolving door. You endanger my town, my officers. It's just not going to go well for you. Their job is hard enough as it is.
Yes, sir.
Is there a co-defendant in this case?
Yes, let me, check the connected,
Please.
for whatever reason, the co-defendant isn't connected. I can
Do
see.
you have a cause number by chance?
Yeah, I can check the offense report and look up.
Yeah, let's, just in case, because it might land in another court. I don't know.
The only thing I'm seeing here, Your Honor, is in transit, prisoner being transported for the co-defendant.
Okay. All right, we are going to reset your case to give you time to hire a lawyer, Mr. Catan. So for now, I'm going to have you sign a reset. You'll eventually get with Veronica for your bond conditions. Also, you're not to be in possession of any weapons. Do you understand?
Yes, Your Honor.
Okay, please.
So I'm just gonna look there, sir.
Don't worry about it. I'm going to have it monitored, so you don't need to file it. He'll be with Veronica.
Okay, Judge, bottom of 17, perjure.
Good morning, Mr. Perjure.
Morning, sir.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed, sir.
On June 23rd, 2026, officer was dispatched in regard to the family assault. The complaint witness stated she got into an argument with her boyfriend, the defendant, who she's in a dating relationship with and resides with, on June 21st, around 3 a.m. The complaint witness was laying in bed and the defendant got upset and got on top of her. The defendant positioned himself on top of her waist area with his knees near her armpits, preventing her from moving. The complaint witness stated the defendant began screaming in her face and calling her names, then intentionally struck the complaint witness's forehead with his own forehead, causing her pain and discomfort. And the complaint witness's injuries matched this account with a visible knot above her left eyebrow as well as bruising.
Got it. All right, sir, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this complaining witness and not to be in possession of any weapons. If you violate this court order, then I will revoke your bond and put you in jail. This is not a revolving door. If I have to put you in, there will be no more PR bonds for you. There is a protective order that has been issued and you need to get to know it. If you violate the protective order, they can file additional cases. Just don't have any contact with this person. Don't use illegal drugs. Don't use alcohol. You will be monitored. Don't pick up any new cases. I'm not asking much. You understand?
I did have one request, if I might have an hour to get some supporting documents. I've been just
So
looking.
you need a lawyer. So we're going to reset your case to give you time to hire a lawyer. So you need to go out there and start interviewing people and hiring a lawyer. When you come back, they'll be able
My
to
issue
help.
is I've not been able to obtain any of my work stuff because there's been difficulty working with through third parties. to obtain this stuff and
So a lawyer is really the best person that can help you out to help you navigate through this thing because they can tell you what you can and can't do. So I'm going to have you sign a reset. We'll just have you sign your bond conditions after that. You'll be free to go. All right, sir, please. You got it.
I have time for your reset injection.
just the next court date.
Yeah, yeah, of course, always. Yeah, Veronica, if I say no alcohol, no drugs, always random.
All right, Judge, next is bottom of 20. Thomas, come on up.
Oh, and no weapons as well. Let's jump in. All right. Good morning, Mr. Thomas. You are Mr. Thomas. You're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On June 11th, 2026, officers patrolling a public roadway and he noticed the defendant's vehicle had an obscured front license plate, which is on the windshield and could not be read. The officer initiated a traffic stop and noticed a strong odor of marijuana emitting from inside the defendant's vehicle. The defendant stated he had marijuana, and during the search of the vehicle, he discovered behind the passenger seat floorboard a black cylinder container, and inside this container was a green leafy substance consistent with marijuana due to his training and experience, and weighed about 1.11 ounces.
You said he was the driver. There was a strong odor. Is that what you said?
He was the driver, yes.
Yeah, and there was a strong odor, you said, right?
Strong odor, I'm sorry, yes.
Yeah, okay. All right, Mr. Thomas, I'm going to find that there's probable cause to go forward with the case as a condition of your bond. You're ordered not to use alcohol or illegal drugs, including marijuana. You're going to get tested. Do you understand? Yes or no? Do not use. I'm telling you that you're going to get tested. It's not a matter of if, it's a matter of when. You have,
Oh, I'm sorry, I'm just gonna
Okay.
say I did run his license. I'm not showing anything.
so he doesn't have a license to drive?
Not from what I'm seeing on my end.
Mr. Thomas, if you don't have a valid Texas driver license, then you're not allowed to drive. You must also maintain liability insurance in your name. Those are your requirements. I'm just asking you to follow the law. If you don't have it, don't drive. That is also a condition. Do you understand?
Georgia. Sorry about that.
Is it eligible? It's high time for you to get a Texas driver's license.
It looks like it's been. It looks like there's a restriction on there and the end date is 2029. I could try to run it through CCH.
Yeah, that'd be. Mr. Thomas, do you have the ability to hire a lawyer? What do you do for a living? What does that mean? You're about to get on a boat for emergency. What does that mean? I know what a boat is, man, but you're saying I'm about to. What does that mean? I've already signed up and you're shipping off, or you want to sign on? You haven't done. What are you doing with your life? Have you signed up to actually go? I'll have you fill out an application for a court-appointed lawyer. Mr. Thomas, if you pick up a new case, if I have to put you in custody and you are in there when that sale date comes, it's probably not going to be a good thing for you. You understand? There are no mistakes in this life. There are choices, and you either make a good choice or you make a bad choice. You are 22 on number 4. Do you understand? For now, I'm going to have you sign a reset. I'm going to have you fill it out. You'll meet with Veronica for your bond conditions, and then we'll have you talk to a lawyer here momentarily. Was that it?
No, Judge, just one more.
Okay.
Top of 21, Imanza.
You're not getting anything.
You want a cause number? You're talking about that gentleman?
Yeah. I tried to run his driver's license. I can't see anything.
Okay. So, hey, Veronica, no driving with this dude until we have proof that he has an eligible license, because we can't find it anywhere. Okay, you are Mr. Umanzor. Sir, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, sir.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay,
On June 21st, 2026, officer responded to a major accident involving a black 2024 Nissan Sentra that struck multiple barriers and another vehicle on a public roadway in Pasadena, Pierce County. The officer contacted the driver, the defendant, who was the sole occupant of the vehicle and exhibited glossy eyes, odor of alcoholic beverage, unsteady balance, and a staggered walk. The defendant was transported to the DWI room where he exhibited the same signs of intoxication. He was confused, unable to follow instructions, and could not perform standard sobriety tests due to severe imbalance. After consenting to a breath test, his blood alcohol concentration was 0.332 and 0.321. The defendant was
Point what?
by 0.332 and
332?
yes, and 0.321.
Sir.
Stop. Just don't. There's nothing that you're going to say at this time that's going to make any difference at this time. Mr. Umanzor, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. I don't care what your excuse is. I don't care if it's mouthwash, a tequila lollipop, hair dye, boot shine, whatever. You test positive, I will put your butt in jail. There will be no more PR bonds for you. If you have a problem with drugs or alcohol, now is the time for you to address it, because if you don't, I'm going to do it for you, and I promise you're not going to like the way that I do it. You understand?
Yes, sir.
Do you have a license to drive?
Yes, and it is eligible. Yes.
Do you have the ability to hire a lawyer, Mr. Umanzor?
Yes, sir. I just need time to get.
We will give you time. I'm going to have you sign a reset. You'll get with Veronica for your bond conditions, and then after that, you'll be on your way. There are no mistakes in this life. There are choices. You know that there are bond conditions. You either make a good choice or you make a boneheaded one. You understand?
Yes, sir.
No, I want him to take it with him at all times, so I know that he's not using. Yeah, I don't care. Just that. Tell me. Yep, yep. If you skip blows on that portable device, you will go to jail. Do you understand? I will revoke your bond. There is a blow schedule that you must adhere to. You skip, they will file a bond violation report and I will have a hearing. You understand? Stop. These are the bond conditions. That's it.
No, I just have questions about the device, sir.
They will give you details. They do the logistics. I'm just the one that's going to put it on. All right? All right,
Sorry, we had me.
please. Mark Metz.
Page 10 and 11, Judge.
Got it.
Good morning, Judge.
Hey, good morning.
I represent him.
Is he here now?
Yes.
Mr. Guevara, come up. Mr. Guevara, you're charged with assault of a family member. You've now picked up 2 more cases. You're charged with failure to stop and give information. You're also charged with false report to a police officer. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Your Honor, did you want probable cause on the?
Not the assault, but the 2 new ones.
Okay. On April 17th, 2026, officers dispatched a failure in stopping giving information collision that occurred. The officer made contact with the complaining witness who advised she was crossing an intersection after observing the defendant's vehicle run the red light and was then struck by a different vehicle. The witness then stated after following the defendant's vehicle, she was unable to keep up and was behind complaining witness as she entered the intersection and was struck by the defendant's vehicle. The witness followed the vehicle and took pictures and video of the defendant's vehicle before it fled the scene. And the officer was advised the defendant's vehicle was in front of the police department. The defendant had a female passenger and advised he had recently picked up the vehicle and his friend Isaiah was supposed to follow the defendant and that Isaiah was the one who was operating the vehicle. The defendant stated Isaiah had left abandoned the defendant's vehicle somewhere. And when the officer asked the defendant for a picture of his friend / contact information for Isaiah, the defendant stated he did not know or have his friend's information. When the officer asked the defendant for driver's license and identification, he said he did not have it with him. And after providing name and date of birth, upon looking at the information, it showed that the defendant / Isaiah were the same person, and there was heavy front edge damage observed on the vehicle.
What time of day or night was this? Was this late?
It was at 5:25 PM.
Okay. Mr. Guevara, as a condition of your bond, you're ordered not to consume alcohol or illegal drugs, and you will get a scram on your ankle. So I know that you're not consuming alcohol. You're ordered not to drive at all. I don't care what you have to do. I'm ordering you not to drive. And you will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, your bond is at $10,003 on the assault. They gave you another $100 on each of those cases, which I find just wholly insufficient. But this guy should just really, in 1 year, we're 1, 2, 3, 4, 5, 6, 7. In a year and a half, we're up to 7 cases. How do we ensure that we don't have any more? Mark, I mean, really, what bond conditions do we put to ensure that? State, riddle me this, riddle me that.
I recommend, in addition to the no drug alcohol and the no driving affidavit.
We had that already prior to all this.
Analysis if needed. Unless you've already added that to the conditions.
Like just as previous conditions had no contact with the complaining witness on the assault and offender.
Okay, was there, do you know, was there any contact?
I don't.
I don't think they didn't list that.
It's probably a good idea to put a curfew on him as well, so he's not out at night.
The state would also suggest home confinement.
Yeah, I agree, but I just don't want him out at night. Well, I don't know. How do we know that? How do I know he's just not sitting in a chair? You know? So, I'm warning you, Mr. Guevara. The only thing I have left at my disposal is to put you in jail. Really, I have no further bond conditions at my disposal to protect my community. If you do anything, pick up any cases, violate any conditions, then I'm going to put you in jail. I've made people's bonds in the millions of dollars before because of self-control and the lack thereof. Do you understand? Hey, so let's do a curfew of 7 to 7 with a GPS monitor, no alcohol, no drugs, testing weekly, so we know he's not using. So tell me,
I'm not going to do.
the assault is 221 days. It's time to determine what we're going to do. I'm not holding this open because he just picked up 2 new cases, so we need to figure out what we're going to do.
I'm ready to move on the assault whenever I have to. I said, I'm ready to move on the assault whenever I have to. The reason why we're here is because of the case.
Sure. Okay. So you guys tell me what you want to do in the assault, and then I'll have him apply for a court-appointed lawyer on the 2 new cases. What's the deal, Pickle?
Assault is ready to go. I think I made an offer, so we just need to talk.
Okay, talk and then let me know, and then we'll go from there. And then I'll have him apply, if you don't mind giving him an application, and then we'll take a look. Okay.
When you're trying to work, he's also defer and defer. You want to take it for 2 cases?
Yeah, I'm not going to hold this. It's 221 days. I'm not going to just, right. Yeah. I'm happy to do it.
Okay.
Yeah, for sure.
Judge,
Okay.
how much time on the oldest case?
Yeah. Okay. Are you ready?
Judge.
Good morning.
Actually, this is off docket. It's on tomorrow's docket. Bonus.
Do you want to take care of it today?
No, actually, it's already, ADA John Hyde offered us a 30-day PTI if he did the racing course, which he did. but then he also had 26 hours of community service, which last month there were 2 weeks of rain, pretty much the whole week. All I need, Judge, is another 2 weeks, so he can.
How old is the case, though?
180, how old is the case? I think 100, it's a little over 180 days, Judge, just slightly over 180.
Yeah, I'm okay.
I was gonna say he's working at Council State Proof of Employment instead of community service.
He is working.
Like I got proof of employment, I can see that stuff.
Okay, thank you, Judge.
Do you have everything done already or no?
I've already sent her the, proof
Yeah,
of-
so if you give him proof of work now, they'll dismiss it today,
Okay.
you know? And then you don't have to. It's up to you, otherwise I'll,
If I have to.
yes,
Thank you, Judge.
yes, ma'am,
I appreciate it.
for sure. But understand there are no more waived appearances, though.
Thank you.
Yeah.
Got it.
Okay.
Thank you, Judge.
Mr. Correa, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 30 days in jail with credit for the 2 days that you've done. You have some jail time to do. I will allow you to turn yourself in on Friday, but you need to understand that you're still under bond condition in this court. Everything still applies until you've satisfied that sentence, meaning that you've gone to jail and done the time. Otherwise, until that time, if I find that you use, and I don't care what their excuse is, you will go to jail. Do you understand? The full range of punishment is available at that time if you violate any condition between now and the time you go in. You are giving up the right to a trial, the right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This will go on your record. What happens on the next one? Mr. Correa? Prison time up to 10 years in prison. If you thought this was expensive, wait till you get to felony court. For the rest of your life, even if you have a sip of alcohol, I wouldn't get into a car. Your records, books. What do you think is going to happen when you get pulled over? Every single time. Do you understand? How do you plead to the offense of DWI-2nd, driver while intoxicated second, guilty or not guilty? I'm going to find you guilty. I will follow this agreement, send you to 30 days in jail, give you credit for the 2. I'm going to suspend your license for 1 year.
Judge, the ALR's suspension goes to April 17th, April 14th of next year.
I'm not going to give him, I'm not. It's a DWI-2nd. On a first, okay, people make mistakes. On a second, and with this, we're not going to keep rewarding them. At some point, the DAs, the officers say, well, this guy's just not getting it. What the hell do we have to get his attention? Jail's not working. How about some prison? That's the next step for people who just don't get it. $30 button on your phone will get you to wherever you want to go in this life. You understand how much money have you got? As much as I want him to make as much money as possible, how much money have you given him when $30 could have gotten you wherever you want to go? Sorry.
Understood?
But no, you will be serving the full suspension. You need to understand the pang of what it really feels like. This is a privilege. It's not a right. I will waive the super fee though, for you. I've now waived about $6,000 of fines and fees for you, but if you pick up another DWI, really. All right. Good luck to you, sir. We'll have you see the clerk.
Thank you, Judge.
Thanks, guys. Come on, come.
I have to clear your honor when you're ready.
Balderas.
Yes, sir.
So it never worked out, I guess, right?
Right. I paid it.
I will tell you,
I paid restitution on it.
you know, one day you're going to kick yourself in the tuchus over and over. You had the ability to have this DWI dismissed, and now you're pleading guilty to it, and it will go on your record, and it will be there for the rest of your natural born life, and it would be held against you for the rest of your natural born life. Every time you want to get insurance, you're going to pay 10 times what the normal person will pay. And insurance now is insane as it is because of the liability. Anytime you want to get a job where a license is required, this will always hinder you. From now on, you will be facing a minimum of 30 days in jail. There are no more proverbial slaps on the wrist. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, Confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This is a final conviction today. It will go on your record and it will be there forever. How do you plead to this offense? Guilty or not guilty?
Guilty.
I am going to find you guilty. I will follow this agreement. Sentence you to it. I'm going to suspend your license for 180 days. You are not allowed to drive. If you're caught driving, that is a Class B misdemeanor, just like a DWI, up to 6 months in jail. Do you understand? Okay. Good luck to you, sir.
Thank you, Judge.
Thank you.
Good morning, Judge.
Hi.
Motion on a plea for Vashti Mendoza. Now, motion for community.
We're doing a deferred. Deferred. Sure. Yeah, of course. Good morning, Shatori. Good to see you. How are you? I know, right? All right, Ms. Mendoza, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You worked out a great agreement. This is a deferred adjudication, which is a type of probation that if you complete successfully, there's no conviction on your record. This is extremely important because you get a theft on your record, it closes many doors. If you ever want social assistance, if you ever want to get a job, people don't hire thieves. You understand? So you must make this work out. I mean, there's really, for you to complete this successfully, you must do an effective decision-making class, 8 hours of community service in an anti-theft class, no drugs, no alcohol. Where was this from?
It was from
Please.
Pasadena Food Mart.
Okay. No more going back to the food mart as well. You understand, while you're on this probation, you were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you were not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it successfully or it gets revoked. If you do something to violate this agreement, I will issue a warrant for your arrest. I'm going to put you in jail. We will have a hearing to determine if you violated this agreement. If you do, you were looking at 180 days. I'm sorry, a year in jail. Do you understand? A year in jail you're looking at if you violate this agreement. So she had the ability to have this dismissed. She had a dismissal offer and she just didn't get it done. Is that what happened?
So we did not have opportunity for it to be dismissed. They were, the state was able to talk to the complaining witness. Last time he came to court, my client wasn't here, so we did get the documents from the hospital. If you don't want them, but
No, I'm just,
but outside of that,
it looked like there was an offer at some point for dismissal. She just did 2 classes and got the,
correct. But unfortunately, she was at the hospital. So this was.
all right. How do you plead to this offense? Guilty or not guilty, man? I'm not going to find you guilty. I'm going to withhold your plea of guilt. We will wait 6 months to see if you can complete this, but there's no excuse. Everything here is based on time. You must do things on time. This isn't how you want to do it. It's how you're ordered to do it. And if you fail to complete it, there's a serious consequence. I mean, really, we can finish this either the easy way or the hard way. That depends on you. But at some point, your decisions become your own and you have to do what you promised that you're going to do. You understand? Okay. Waive the fees, please. So it's not about the money. We're not going to charge you for anything. For outside classes, I can't pay for that. But as far as here, I'm waiving all your fines, all your fees. There's no excuse for you not to get it done. Okay. All right. Good luck. We'll have you speak to Story and then,
Thank you, Judge.
yep. Thanks. Counsel.
Good morning, Your Honor.
Good morning. How are you? What's up?
Coming for the streets.
Bond or jail?
See, are you, is it a
Is he in jail?
No, he's a,
Bond.
he's a Chinese.
All right. Have we done PC before or no? Okay.
I just got on the stage.
Derek Davis, come up.
Judge, you have another arraignment after this one.
Okay. All right, good morning, Mr. Davis. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
June 14th, 2026, while on patrol, an officer has observed the defendant's vehicle in the public parking lot of a Shell gas station at the address of 9805 Main Street. The vehicle was not at a gas pump and was not in a parking spot. The driver of the vehicle was asleep behind the wheel and was unresponsive while the engine was turned on. There were heat waves coming from the vehicle and the headlamps were turned on. After observing that the defendant was unresponsive, the officer attempted to conduct a welfare check on the driver. The officer then observed the driver traveling at a high rate of speed and leaving the gas station parking lot.
Saw him driving at a high rate of speed out.
And the traffic stop was initiated. And then at that point, the officer made contact with the defendant and had detained him. The officer observed a distinct odor of alcoholic beverage coming from the defendant's breathless person as well as glossy eyes. And then at that point, the defendant had stated he had wine the previous night. Standard sobriety tests were followed, 6 out of 6 HDN, 6 out of 8 walk and turn, 3 out of 4 one leg stand. Breath tests included 0.155 and 1.147.
So he's at a gas station
Yes,
and someone sees him passed out?
yes.
Okay.
So Your Honor, skipped over some things in the report. It also said that he attempted to do a welfare check based on reasonable suspicion. And y'all know, under the law, that reasonable suspicion and welfare check, a reasonable suspicion goes to a criminal investigatory approach. So if you have reasonable suspicion that a crime occurred, sleeping behind the wheel in the car in the parking lot, there's no way you can lock somebody up for sleeping behind the car. So,
No, I understand that, but is it enough to just go and investigate further?
well, he said based on reasonable suspicion, he tried to do a welfare check.
No.
Okay.
Based on, he's asleep at the wheel,
He's
parked at a gas station, he's unresponsive.
And he wasn't on a pump or anything like that.
So where was he?
It looks like he was just,
It doesn't say. It just said it wasn't at a pump or in a park.
wasn't in a pump.
But he's at a gas station.
It said
Yes.
yes.
And does he try to rap on the window and then that's when he wakes up and just booms, takes off?
So what I have here is,
The report doesn't say that.
he observed the driver to be unresponsive. It does not specify, what he had done to try to wake him up.
Okay. So how do we get from, how do we get from, I know he's unresponsive to, I see him just bolt out.
It looks like as he attempted to conduct a welfare check, the driver had then driven off.
So the other, it said, and that's a description I have in the report. It says that he's attempted to, first he says he's unresponsive. And he attempted to do a welfare check. How do you know someone is unresponsive without doing a welfare?
Well, I'm assuming he's saying, look, I went to go do a welfare check. I go up to the car, the guy is unresponsive. And then I guess at some point, just boom, he just jets out of
Takes
the,
off, right? It said it takes off at a high rate of speed. Never said that he's speeding or anything, he just takes off. Leaving the parking lot fast and the gas station can be 5-10 miles per hour. That doesn't mean that he broke a law. Then when you further go down the report, it says that upon turning lights on in behind the defendant, he immediately pulls him over, and orders him out of the car and places him in handcuffs. So he then said remove them to a different location under the factors of the de facto arrest, not in detention or criminal investigation, without being probable cause stated by office.
what do you say about that?
I say that, because during the welfare check, the defendant had fled the parking lot, the officer did have a reason to initiate a traffic stop. And I would argue that it wasn't an arrest, but it was a detention. And because the officer had detected the odor of alcoholic beverage, I believe that this would be sufficient.
Well, I'm just looking to see if there's probable cause enough to, you know,
Didn't, after placing him in the handcuffs and ordered him out of the car, and the officer didn't smell.
Does this say that in the report?
Before. It said after I arrested him, placed him in the handcuffs, I detected an aroma of alcoholic beverage.
I have here, after placing him in handcuffs, at that point, he detected the odor of alcoholic beverage.
But getting to handcuffs is the problem I have with the proper cause. Constitutional.
What do you think?
I would argue that because he had left during the welfare check, and had left the scene while an investigation was occurring, the officer has reason to stop him and to detain him. And
Right, but you know, you pull them over and you, first thing you do is you start putting people in handcuffs. I mean, we shoot first, ask questions later. You know, is that what, or would a proper investigation be, you know, get them out? Well, I smell alcohol, you know, and then you start doing your investigation at that point, as opposed to, I mean, you know, if you got handcuffs on, that ain't free to go, you know? Yeah. What's his name again?
Jerry Davis?
Mr. Davis, you know, I was just seeing on the news yesterday about how a young officer was killed just trying to help out a DWI. You know, really, there are so many ways for you to get home in today's environment if you know that you're going to go out, you're going to party, you're going to do this. Because really, I would say most of the people in this life, arrogance takes over. And they think that they can, oh, I can do this, I can do that. And then when the reality is that, you know, the chance you're taking is just so not worth it. You understand? It's not hard in this life. If you do the right thing, life tends to reward. You know what I mean?
Yes.
All right, I'm going to find no probable cause. Okay, you got it.
Judge, October 7th was another arraignment.
Did they just come?
No, they came right before the attorneys lined up.
Good morning, Ms. Chavez. Ma'am, you're charged with hindering apprehension. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On June 12th, 2026, officer was patrolling when he recognized Rodney, a witness by name and date of birth, and had knowledge that Rodney had a felony warrant for failure to appear. The officer advised Rodney to come over to him, but Rodney instead ran into a camper and shut the doors. The defendant stepped outside and asked the officer what he was doing there. The officer explained to the defendant that Rodney had an active warrant for arrest and advised the defendant to call out for Rodney. The defendant stated that the male observed was not Rodney, but was in fact David Robert, and the defendant refused to give the officer consent to enter the residence. But the officer explained to the defendant who he observed to give her a second chance. The defendant continued to deny that the male was Rodney.
So did they go in there and get Rodney?
Let me see. Yes, they made entry into the camper and placed him into custody.
Got it. All right. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm not going to put any conditions on your bond. Just be careful. Do not pick up any new cases. You understand? You have the ability to hire a lawyer, ma'am.
I'm unemployed.
Why?
My job ended, my project ended. I work from home. I'm a political campaign surveying, customer service agent, and
Okay.
still.
So you need to be working full-time or need to be in school full-time. The people of Harris County don't get to pay for a lawyer for you and you get to sit at home and play Xbox all day. It don't work like that.
Okay. I promise.
Well, do you want to apply for a court-appointed lawyer?
Sure.
Okay, I am going to make it that you must work. I'm bringing you back in 2 weeks and I want to see what you have done to get a job.
Okay.
You understand?
Yes, sir.
Okay. All right. We're going to have you fill out the application and then when you're done, come back. We'll have you swear to it and then we'll have you sign a rescindment.
With state's own conditions.
I'm not putting any conditions. No. Darla,
Yes, Judge.
what's up?
So we're back on Cassandra Rangel. This is the PTI that we were trying to get approval by the deputy chief. And then from there, she did her TRAS last week.
What's the last name again?
Rangel.
Oh, right. Rangel.
Mhm.
What's the deal, Pickle?
So, I can update quicker.
Okay.
So we got the PTI agreement from Kenneth on 2 business days ago. My client now has it. We're working on it. And I anticipate a week being plenty of time to get it done and back to the court. Well, back to the DAs, to the court to have a
Yeah.
supervision order.
She did a TRAS, Rangel, right? Okay. Yeah. You want a week?
I do. I mean,
Yeah.
if you're willing to offer more time, I'll take that, but I know I can get it done in a week.
Okay. Yeah, I'm down. Okay. So Victoria, do you hear that? Who? Yeah, Rangel. Uh-huh.
How's July 7th through the 9th?
I don't know why I said that. Okay, so I'm on vacation that week. I'm still working. And if you don't require a parent to do the supervision order, I can get it done and I'll gladly put it on that week.
Yeah, let me see how old it is.
It's old. You keep saying that every time we come.
Yeah, so just pick a day next week. All you got to do is literally pop in for 1 second. You know what I mean?
Okay, July 7th works.
Okay, we'll give it to you. Okay, Darla.
Thank you, Judge.
Thanks. Have fun.
I will.
All right, Mr. Haley, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you, let's see, 3 days in jail with credit for the 1 day that you've done. Is this how you understand the agreement? You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This will now reflect as a conviction on your record. It's now a minimum of 90 days in jail. You understand?
Yes.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm assuming the weapon is forfeited. Okay, the weapon will be forfeited. I will roll your court costs. You won't owe anything. But remember, it's a minimum of 90 days in jail now. Do you understand? Okay, good luck to you, sir. Thanks. You got it. Take care. Hi, Ms. Childs. Hi, good morning. What's up? What's the last name?
West.
West.
Judge, this is Spring Dickerson. This is my legal intern for the summer.
Hi,
She said
nice to meet you.
she's in a few weeks. I just wanted her to experience this today.
Yes, absolutely, of course. So we got
He has a BDR, I think, for not getting his portable device, but we brought his treatment coordinator from San Marcos. That's where he's been getting drug treatment and other about for where he's been.
great, but you can't just up and go and not let anyone know and just,
Right, so I think the issue was, we worked out the agreement with the mental health prosecutor, Lawrence Stubbard. We agreed that he would work with mom to get in the treatment program. And she tried to get him in the treatment program all across the state, and it was unsuccessful. But the treatment program in San Marcos took him like right away.
so tell me about it. Is it inpatient? Is it outpatient? Is it, how long is it? Has he been in it?
Residential treatment facility, it's a 30-day period. He's going to groups.
How long has he been in?
He's about 3 weeks.
Okay,
He's doing well. He's progressing. He's intentional. He's showing up and he's doing great. We're proud of him being able to come forward as well, just taking care of his responsibilities, being intentional with what he's doing. He's progressing very well with him.
does he have the device on now though?
Yes.
Stacy, do you know?
He's having his glow.
Does he have an ankle monitor on now? Is it operational?
It's not operational. So that's what the DDR was for. It wasn't for the portable device.
So can we get it operational now so we know where he is at all times? Okay, let's do that. I need to know where you are. When you're on bond conditions, you can't just up and go. We need to know where you are. Do you understand? Okay. All right, we'll continue supervision. So he has about another week left in the program, right?
Yeah.
And then what?
And then he'll receive the continuing care if it's Friday.
Is there an aftercare?
There is. He's working with case management now to pursue the next steps, but we just haven't fine-tuned where exactly he's being transferred to after treatment.
Okay.
But it's going to be ironed out with case management as well as his therapist.
As Ms. Childs, as far as this case is concerned, are you telling me that after he completes the program, that this will be,
No, he's gonna be able to PTI until September 9th.
okay, supervised PTI? Okay, that's great. I think it's a good idea. That way we know where you are at all times. Just stay on top of it, you know. Is he taking any other medication now, Mom? Do you know?
No, taking the facility.
So he is in current medication with you now? Okay, just keep taking it. Don't stop. All right? Okay. All right, we'll continue supervision. We want him, just make sure that, really, we're not asking for much. All right, okay.
Thank you.
Good luck, Mr. West.
Thank you.
All right, thank you, Ms. Charles.
He needs to do
And the only other person I have is Grace Sims.
Okay,
She has a DVR as well. I don't think she showed up today though.
I don't see a Sims.
Oh.
Is Sims on the docket?
Person.
Sims is the last name?
That's it, Judge. I thought it was today.
Okay, it's got to be, let me see. Maybe I have it outstanding and we need to set it. Sims, I see, all right, I see it. It's tomorrow.
Okay.
So just let her know she's got to be here tomorrow, please.
Okay, thank you.
Okay, thanks. Hi,
Good morning.
good morning. You ready? Hey, what's up?
I am here on a case that you had found no PC on. Can I have the cause number if you would like it?
You ready?
She sent me. She sent me.
All right, what is it?
It is 262-0056. It was a UCW where him and a few other friends were hanging out outside of a car and the police were called and they went up, arrested one passenger who took possession of a handgun and then he took ownership of a rifle. They rejected the co-defendant's charge on the handgun.
I vaguely remember,
Right, and I
right?
was on Zoom when this one happened, but you had found no PC. We had filed a motion to restore the rifle, not the handgun, back to our client, if the court would allow.
Yeah, but I want proof that the gun is actually theirs because I've returned a weapon to the wrong person before. I'm not going to just return a weapon. I need to know it's theirs. So if you give me some kind of proof, then I'm happy to do it, but I'm not going to take, oh, hey, it's mine, by the way. I did that before and it was a complete and utter mess. So
Yes, understood.
give me proof. Did you file a motion already?
We did not.
So just do like an addendum or, amended motion, add the proof, let them see it. If they're okay with it, then we'll give it back. But I want to make sure that if I'm going to give it back, it's got to be to the actual right owner of the gun.
Understood, yes, sir.
Yeah.
Thank you.
Yes, ma'am. Go. You want to go through the list?
Yes, sir.
Bottom of 12, Art. You picked up 2 cases, the custody apart.
Okay. Where's Mr. Hart now?
So here.
Got it. So on today's case, 2501. And then we'll wait for the interference case for, I guess, next week.
Top of 17. Oh, Brian.
Yeah, 5002.
Yeah.
Yep, right now. I got Mr. Stambaugh here, by the way.
Judge, this case was no PC, probably just trying to see if you're going to dismiss it.
Okay. Do you know? Okay, got it. Good morning, Ms. Jimenez. Ma'am, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 3 days in jail with credit for the 14 days that you have done. You need to understand that this charge will now reflect as a conviction on your record. It will be there for the rest of your life. It's now a minimum of 90 days in jail should you pick up any further of these. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, deny naturalization. You give up the right to appeal. So once you plead guilty, it cannot be undone. Is this what you want to do? How do you plead to the offense, man? I'm going to find you guilty. I'll follow the agreement, send you to it, and good luck to you. Thank you, Mr. Fleischer. You are? Hey, Joel,
Good morning, Judge.
you're going to dismiss it.
Perfect.
Yeah.
You have a great day, Judge. See you
You too.
later.
Take care. Thanks,
Thank
State.
you.
Good morning, President.
Yeah, come on. Hi, good morning. Who we talking about?
Judge, I got appointed to Ms. Chavez, Jessica.
I didn't put any conditions on her.
You don't mind?
Sure, of course. Yeah, absolutely. Tell me.
Judge, Ms. Chavez is charged for hinder apprehension. I believe there is no probable cause for hindering apprehension. Section 3805 requires an intentional act of harboring, concealing, warning, or providing to avoid arrest. The officer's own statement in the DIM says Rodney ran into the camper and closed the door before Ms. Chavez came out. There's no allegation that she invited him inside, hit him.
I agree with you, but he sees Rodney go in and he asks her, hey, can you have Rodney go out? There's no Rodney. That's not Rodney. That's whoever. Is that providing assistance?
Judge, I don't think it's providing assistance. It's saying like it may not be him, but it is also her refusal to consent to a warrantless entry as well is a problem.
Well, that's exigent circumstances. I mean, it's crim law 101. You see someone running into, it's with a felony warrant, you know they've got a felony warrant. They see him running into it, right? Yeah, I think there's PC.
Yes,
Sorry.
can I be excused?
Yes, ma'am.
Thank you.
Thanks. Hi,
Morning,
good
Judge.
morning, Ms. Strong.
I have Mr. Pena on docket today.
Okay,
He's currently charged with a terroristic threat. He has a bond set at $200 by the magistrate. He has a place to stay. He currently is going to live with his mother. I have the address and everything, his phone number for mother.
have you verified it?
Yes, talk to mother.
Okay,
She
great.
is, and then he is also her caretaker, so he has a place to stay. I'm just requesting the court, he can be granted a PR bond. So that he's not awaiting while we reach this position for his case.
What do you think, State? What's your position?
So we haven't been able to get to contact with the complaining witness as yet.
It says here, mismarked as a GOB, domestic violence is unpredictable and at high risk for repeat incidents. This court cannot set a condition that would reasonably protect the complaining witness's safety due to the nature of this type of unpredictable violence. There is therefore clear and convincing evidence that no less restrictive nor non-financial alternatives exist to ensure complaining witness safety. Indigent, cares for parent with health issues, minor children other than complaining witness. He has a prior assault, same complaining witness.
Let me check.
I mean, granted, they're pretty old.
Yeah,
So-
we discussed the root cause of this issue is his alcohol use.
if we can maybe do jail release instructions, if he is willing to do any recovery treatment, there's just
Well-
council of recovery that will do a drug and alcohol screening on him.
No. I'll put a scram on it, so I know that he's not drinking,
Okay.
you know? Hey, Deputy, do you mind bringing out Mr. Pena, please?
We do plan on, while the case is pending, we do plan on getting him some alcohol treatment. He is completely on board for that, and he understands that the alcohol is his issue, so.
Is he supposed to be taking any medication too? Do you know?
Currently, he is prescribed, yes.
Well, you don't have to tell me what. I'm just saying, is he supposed to and is he not? Because if so, then we'll make that as a condition as well, that he takes.
He is taking medication. He's currently on medication as we speak, so it doesn't say that he's not compliant with it.
Okay. Good morning, Mr. Pena.
Good morning, sir.
How's jail? All we want are our streets safe. And anyone that takes issue with that, really, there's only one place that we have for them. The crazy thing is for you, it will literally cost about $25 to get you out of jail. $25, if even that. You know, by you sitting here, at least, when did you get arrested? Saturday?
On the 26th, Friday?
So since Friday, you've been here, you now know there's no one to even pony up $25 to get you out of jail. So when you're out in the free world and you're doing something and you got, if this happens, could I be going to jail? This is what you need to be thinking, because not even $25 to get you out. Your lawyer's asking for me to give you a PR bond, and I really believe everybody should be given a chance at least once, and I'm willing to give you that chance. But it will come with a host of conditions that I hope you adhere to, because if not, really, not even $25. You understand?
Yes, sir.
That really sucks, you know?
Yes, sir.
Either someone doesn't have the money, someone doesn't trust you enough, but really, if you get out of jail, it's because we give you a PR bond. But I have to know, if we're going to do that, that you're not going to go out there and just wreak havoc. Do you understand?
Yes, sir.
And a lot of times, one of the major things that really gets people is either alcohol, dope, you know, or one more thing, which is the root of all evil, which is what? Money. So no alcohol, no dope. And I'm not going to take your word for it. You must get a scram on your ankles so we know that you're not using. You use, you will go back into custody. Do you understand?
Yes, sir.
And there's no excuse, none of this. It was isopropyl alcohol. It was mouthwash. It was whatever. I don't care. Do you understand?
Yes, sir.
I'm not asking for much. So the terroristic threat, who is the complaining witness? Is it mom?
It's this,
His son? You are not to have contact with this person.
Yes, sir.
Do you understand?
Yes, sir.
I understand that's your son, but it just, no means no. Doesn't mean, well, we got a football game. Doesn't mean we got the World Cup going on. Doesn't mean, no means no. Do you understand?
Yes, sir.
So if he's living at this house, he can't go back.
yes, he's not going to go back. He'll be staying with his mother.
Okay, so it's going to be split. They're not going to
Yes,
have
they're
any.
not going to
Okay.
be in the same.
All right, so you need to understand that there's a protective order in play as well. You need to understand those conditions, follow them, because if you don't, they're going to just tack on more cases. A violation of a protective order is one of the worst ones you can pick up. Do you understand?
Yes, sir.
We are going to give you a PR bond today. You have to stay in contact with Ms. Strong. You have to come back tomorrow so that you'll probably be let out within the next 8 hours, but tomorrow we're putting you on for the docket. So you got to come back so we can give you the alcohol monitor. If you don't come back, I'm going to revoke the PR bond. I'm not going to do this again. It's not a revolving door. You understand?
Yes, sir.
You have one chance to make the right decisions, and there are no mistakes in this life. You understand?
Yes, sir.
Okay, Mr. Payne, good luck to you.
I would like to add that the second complaining witness on the case, I believe, is the mother. I can attempt to make contact and see if she's
So
okay.
the complaining witness, is the son, and he's a minor, so I believe that the mother is.
It says, yeah, it says LP as in the information. So I don't know if you see something different.
Yeah, for whatever reason, it's showing up, on my end as, she's married to the defendant. I'm sorry, not the mother. It looks like, the second complaining witness is, the person who was previously for the AFM in 2015. I don't know if you wanted to add that to the, if there were already bond conditions, already contact between them.
I don't know. I mean, unless we
She's
have
not
more.
going to go to the house, so he
Okay,
is not going to be in contact with mother or his son until the case is over.
if whoever you have a volatile relationship with, if you do, just be very careful. $25. You know what I mean? Really? All right, come on. Make me proud, man.
Thank you, sir.
Just
Thank you, Judge.
make right decisions. That's it.
I appreciate this opportunity.
Really?
David Fleischer.
Thanks.
Maybe-
Yes, ma'am. Of course.
So for bond conditions.
Yeah, don't, he's going to be monitored, so we'll do the scram. So we're going to roll it till tomorrow. Or I guess if you just want to give him conditions now, then he can just head tomorrow morning or whenever he gets out. It's probably going to be closed by the time he gets out, but tomorrow morning, 7 in the morning, he can head on. Yeah, okay.
Do you want, no patterns and what?
Yeah, of course. Yeah, no weapons, no contact, no going to where they live, work. No alcohol, no illegal drugs, and then random testing as far as the illegal drugs. Okay, ready?
Good morning, Judge. How you doing?
Hi, Mr. Leonard. How are you?
The state has asked that we, back in today and approach on off-docket matter for trial set next week.
Okay,
It was the case, I'm sure you remember, the gentleman's got 6 cases.
sure.
And, the state was wanting to see if you'd be open to reconsidering the original plea offer. Now that he's
Which is what?
custody. The original plea offer was the time served on the DWI-2nd and
What,
that.
we did the TRAS. What did the TRAS recommend? It was the one, dude's got 6 cases, right? Remember Martinez? I'm not going to just take a time. I think I don't want to just continue what's going on. And I think that,
I believe it was recommended.
yes, then I think that that's what's appropriate. Right, yep.
Look at my notes here. Okay. Thank you
Sorry.
very much, Judge. I
Oh,
appreciate it.
got it. Lindsay, you ready?
Yes.
Hi.
His last name Caesar. Fugitive
Yes.
bond hearing.
Hi. What's your position?
The state's gonna ask for a bond of $15,000
It's a lot.
because his charge is felony monetary instrument abuse. I have more facts on what actually happened, and it appears that.
Okay, hold on. Let's bring him out so he can hear it, if you don't mind.
Yes, because I know he doesn't know this.
I guess, yeah, Lindsay, if you don't mind asking Ed Schmidt to bring him out, that way we can,
Of course.
I want him to hear it so that he knows. Yeah, okay, sure. Justin,
What do you think, Judge?
hey, bud, you ready?
Yes, there are 2 cases to approach. One.
Okay.
One is Deborah Michael. She's in custody.
She's in custody. Did she pick up a new case?
She did.
Just later. Which is actually, Your Honor, I know that defense doesn't think so, but I'm okay with it. And I'm glad that at least we got her back in because my goal here is to get an assessment, mental competency evaluation done. Because I know that we had one previously set, and that didn't end up happening. But I'm wondering, counsel and I have spoken and what the best move is here, and I very much want that assessment. And I'm wondering how quickly it could possibly be done. And so that's our first.
What is your position?
I've requested a competency evaluation on our 2 underlying cases she's on bond for right now. And we've had some trouble.
So you're okay with it?
Pretty assessed, yes.
Okay.
My position is, I don't know that we're dealing with mental health issues here as much as we're dealing with mental capacity issues. And I don't know that, the other thing is, she speaks a very narrow dialect of Ethiopian. It's her primary language. We've requested that the competency evaluation be conducted in that. I just don't know that it's going to result in a whole lot. I understand the state wants it, we're going to check some boxes, and it needs to be done, but I don't know, we're kind of hanging our hat on a hook that I don't think is going to be very substantial.
What do you suggest?
I don't know that this system is like built for her, or people who have the issues that she has going on.
So what issue is that?
Mental capacity issues.
Meaning what?
Like.
That she doesn't understand?
Meaning there may be some intellectual or developmental deficiencies here, Judge. IDD is the terminology that we use. It is a blanket, under the blanket of mental health, and we do in felony have a specific prosecutor who handles cases that are IDD. Unfortunately, for misdemeanor,
We get gutted so much, it's just ridiculous.
yeah, we don't have a felony mental health court like that to address. Now, my concerns here are not so much only the present case, but in future as well. I mean, I'm seeing some history and I'm seeing that these are getting fled out. If counsel is raising competency concerns, I very much want to be sure that this defendant, whether she is competent or not, before proceeding.
I mean,
And
what if it comes back, right?
Sure, I get that. Here's my concern is that I think that we've got someone with developmental issues who is, I'm afraid, is going to just get stuck in the Harris County jail, which is not a place that's equipped for people with.
She's not going to get stuck in Harris County Jail with a lawyer like you, Justin. You know what I mean?
Appreciate that, but
I very much.
I just.
I very much would hate
She's gonna
that.
be in there just kind of waiting for the Harris Center to come over and do the evaluation. And I don't want that to be a reason why she's in that place.
Is
with
there
what she has going on.
any way we could maybe expedite that?
Oh, yeah,
I don't know what
absolutely.
powers,
We
like,
can expedite a lot of things. As far as an assessment though, it's still 30 days, right?
Oh, yeah, is it 30 days for the?
When we do a comp eval, we're supposed to set it out 30 days. And sometimes it may take even longer, really.
I understand. I am still in a position that
I don't know, can you expedite it?
I'm not sure, we have to.
We can ask, but I don't know.
Can you ask me to come back in the morning and find out? Just roll over to tomorrow?
Sure.
Back with all-
Yeah.
So I can come back with information from the family, on where they are with social security. We can find out where the mental health people are.
So regardless, she's picked up a new case.
Yes.
What happened on the new case? I don't even know. All I know, she's on bond for 2 cases and she's now picked up a 3rd.
I can give you PC, Judge.
Sure.
June 26th, officer working extra job at the Hillcroft Shopping Center, observed defendant loitering in the location, trespassing in front of a business, made contact with her, and she had previously been warned on November 4th of 2024, as well as June 26th of 2026, so that day earlier, not to give that information. They had a trespass updated on that.
Do you have a position as to the other 2 cases?
On the other 2 cases, Judge, my position is that I am a little bit,
As far,
concerned
she's on
about the
bond.
Activity
Do you have
that
any?
went on, which is why I do want the results of this competency evaluation. I'm glad that we're still here in misdemeanor land. I want to keep it that way, to have some intervention here.
So leave bonds as is.
I'm fine with that.
Yeah, okay.
So just, can we come back tomorrow with all that?
Of course.
Okay.
Yeah. But I don't know if they'll be able to. Imagine how many evaluations by how many
All need to be done
courts.
yesterday.
And
I know.
so,
That's why, but tomorrow, hopefully, it'll be like, this is what we know. And then we can kind of operate from.
all right. So one final thing. Are there any conditions that you guys think that we should place on her in the event that she bonds out?
Nothing. other than
Get your
what you have.
competency assessment.
Okay.
Other than what you
Well,
have.
don't go back to the location, obviously, right?
Yes, that as well.
Okay.
The competency assessment.
Yeah. Okay.
Get it.
Done.
That's 900.
So we'll email now, roll till tomorrow. We'll set it regardless tomorrow, make it a condition and we'll go from there.
Okay.
Okay, for sure. Okay. Ready?
Yes, sir.
Come on up. So this is Mr. Caesar. Mr. Caesar, you are wanted out of the state of Louisiana for the computer will work. Monetary, what is it again?
Instrument abuse.
So, your lawyer is asking for me to set you a bond. I don't know. I don't know anything about you, but I have to get to know you in about 20 seconds to see whether we should set you a bond. Just because we can doesn't mean we should. If we give you a bond, are you going to, number one, go back to the location where you're wanted from? Or number two, and are you going to leave a wake of destruction on your way back? Just, I don't want these things, right? So this is what we look at. And we use a variety of factors, your criminal history, what kind of, out-of-state history you may have to determine these things. So tell me about it.
So I had the ability to speak with the demanding jurisdictions today, and they gave me some background on what actually happened. A Louisiana local business owner sent checks to a business in Houston, Texas, and they proceeded to get a phone call from their bank calling about that specific check, which was then in the defendant's name somehow attached to a Houston address. And as far as Louisiana has given me, they have no idea how he managed to get his name on the checks. And the check was for $4,256.
Okay, so the total amount is 4,000. That's we're talking about.
Yes.
Okay.
And from our perspective, we have no idea about anything. He did not know about the warrant. In fact, he was arrested in Harris County last year and they didn't even do the due.
Is that right? He was arrested and released, or?
Both cases.
One of them was for a lack of probable cause, I believe.
For the fugitive case?
For the, it was the assault of a family member.
No, I don't care about those. I'm more concerned about, so he's been in custody now just for a couple of days regarding this thing.
Yes.
Okay. So you're not opposed to a bond, but you want a high bond?
Yes, personally, I'm not opposed to a bond, but I believe a high bond in this scenario is logical, because if this man has the skill set to somehow fraudulently acquire a lot of money,
Sure.
a high bond makes sense. And I also, as they said, they told me that they had investigators planned to come down and get him on Thursday. So Louisiana is very adamant about receiving him back. And who's to say that if he gets released out on a lower bond, that he doesn't go do this again and he's just a high flight risk at this point in time.
Okay.
We would be asking for a bond of $1,500 because he doesn't have prior criminal history of convictions that I can tell. He also has no knowledge of this warrant or any of the facts associated with the case. And so the fact that his name ended up on it check is just something that he's gonna have to figure out in Louisiana when it goes.
Sure.
I talked to his mom. She really wants to take him there and she's on board.
Yeah, I think $1,500 is just way too low for a fugitive case. You got to understand that you're very right, it's an inherent flight risk because you're wanted from another jurisdiction. So you now know that they're ready to come get you now within the next couple of days. Normally, we have a lot of people here from Louisiana. We have buses coming in 1 to 2 times a week to shuffle in people from back and forth to Louisiana. If you waive, probably within the next 3 days, you'll be back to Louisiana, versus if you want me to set you a bond, I can. I'm not going to set it that low though. I'll set your bond at 5,000. You will have to probably pony up most, if not all of it, just because of the nature of the offense. So it's up to you whether you want to do that or not. But is he refused now, or is
He
he?
just didn't understand the paper, I think.
Got it.
I
So
thought we were ready.
So the options are you can waive extradition or you can try to post the bond. If you waive, like I said, you'll get back to Louisiana, and some might say it might be worthy to use that money to hire a lawyer in Louisiana as opposed to just paying, because if you do post the bond, I'm going to require you within about a week and a half to go back to Louisiana to turn yourself in. If you don't, we'll issue another warrant. At some point, we're going to get you because you can't run forever. And then this time, I'm not going to give you another one. You understand? Okay. So I'll let you guys talk and you make the decision on what you want to do. Okay.
I'll do that.
Okay. Thanks.
Thank you.
Yes, ma'am.
Judge, may I approach?
Yeah, Martin.
Judge, I'm back on the case from last week. Sorry, let me put my video on.
That's okay. Give me your last name, Martin.
Wilson?
Yeah, I'm revoking the bond. She's not here.
Judge, if I may, so I understand that you told her to be here. She's not there. She is in the halfway house in Dallas. And last week, you said that it was a very old case. Judge, I think you might have been looking at somebody else's case because this case is still relatively new. And it wasn't a
She
2B.
failed to appear 2 times, Martin. I don't know where she is. You're telling me she's in a halfway house. How the hell do we know that?
She sent
How do
me
you know
some,
that?
she sent me some paperwork that indicates that she is through her probation or parole officer. I'm sorry, Your Honor.
And she's on parole?
Yes.
Wow. I'm
That's
sorry,
why-
man.
That's why they had her come up.
Did we roll her to today for her to show
Yes,
up
sir.
here?
Yes, sir.
No. I'm not going to just continue to do the same thing with, I mean, at some point she has to show, man. Has she ever been here?
She has her first upon her arraignment, and you reset her for 2 weeks for her to get a job, but her parole officer recommended that she go to the halfway house because she lost, I guess this like her sponsor for the parole said that she couldn't stay with her anymore.
So where do we go from here? I mean,
Judge, would you allow her to appear via? I tried calling her this
no,
morning.
I'm not doing Zoom because I don't allow, it's not fair. I don't allow any defendants to.
I understand.
It's just not fair. So,
I understand. Judge, I was trying to get a hold of her today. She has been in contact with me. I don't know why I couldn't get a hold of her today. But
I'll give you till, later this week. The most
Friday?
Wednesday or Thursday, but at that point,
Thursday.
I mean, it's
Yeah, I
really
forgot we're
3
off
times
Friday.
that we've tried to get her here. At some point, we can't just keep doing the same thing,
I understand. So I'll tell her to be here by Thursday, Your Honor, if that's okay with you. And if not, then I'll tell her that her bond's going to be
super
forfeited.
SFBF.
Yes, Judge.
All right, but that's it, Martin. She's not here then. I'm cutting it.
I understand, Judge. I'm trying my best. Thank you.
All right.
Have a great day. Bye-bye.
You ready?
He just said he just changed his mind. He doesn't want to plead. He wants to go to trial. Yeah.
All right, come up. So, I have enough drama in my life. I want you to understand that if you want to go to trial, great. I will not accept any more plea bargain agreements after today. Your case is 230 days old. I have enough drama in my life and I don't want any more. If you want a trial, wonderful. We will go, but I will not accept any more offers. I'm going to put you to trial, whether you go kicking or screaming. Do you understand? It's up to you whether you want to take this or not. Personally, I don't. But at some point, we got to put these babies to bed. We don't just reset. No. Either today or we go to trial and you will go to trial. And that's it. You guys can talk about it, but really, no, you guys go just.
I mean, this quick. What do you want? You want trial or you want to plead?
No. But look, it's not a game, man. Really. Your case is 230 days old. You need to do the proper research in your life to find out what's best for you. You don't wait till the last damn second to say, oh, damn, what's going to happen to my life? With your rich criminal history, you've been through this game before. What's the last name again?
Bavar, G-E-V-A-R-A.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, now 11, 12, and 13. And you're coming here, oh, wow. No, it's either yes or no. You either did it or you don't and you go to trial. There's no in between. Really, I don't want you to do something that you will eternally regret. You either make one choice or you make the other. I don't want you to come back and say, no, man, there's no buyer's remorse here. This is not Target. If you guys step back so you can make the right decision, really, I just don't want you to talk in front of everybody, really, but. All right, Mr. Casanova. Hey.
I have Mr. Josué Isaac Bardales.
Bardales.
You may recall Mr. Bardales.
No, I don't remember anything. Oh, I remember Mr. Bardales.
DWI messed up the first time, given a chance, and the jail there, so he came out. That's enough.
Did we do T-Res? What it recommended?
That SATF, but Bear County because he's a Spanish citizen.
Bear County. Wow, can we do that?
We can do it, but it's a process, so it'll be about 4 weeks wait list and then
Yeah.
here 6 months.
Yeah, I think that's,
Yes, the probation period ends November 12th,
so
we'll have to
extend it. I'm gonna extend it. He's fast tracking his way upstairs, man, you know? And it's not from a place of hate. It's so that he doesn't graduate to felony court. I mean, the way that he's going.
Well, I mean, I think he doesn't have a whole record. He has some kind of status, but the kind of status that he's describing to me in terms of immigration, I've seen him walk away less. So
I understand.
you know, if he gets treatment and then he gets deported, that's a good thing, I guess, for him.
I don't know, but
But I don't know if you would consider maybe straight jail, yes, 20, not time served. Higher. More jail.
the problem is then we leave all those issues unresolved. And if he goes out and something catastrophic happens, like what happened 2 days ago or last night, you know, really. I think SATF is, so let's extend him a year and try to get him help. It's the right thing to do instead of throwing him out to the wolves. I understand what you're saying, but the reality is that all he's done is sit in custody. He's just ready to get out and start doing the same thing as opposed to.
There's one other possibility I just wanted to recommend to the court is reoffending IOP and SOP.
We tried that, didn't we?
No, yes, he did complete IOP and he completed SOP.
Oh, he did?
Mhm. We just haven't done like a really abstract.
No, I mean, and the thing is that with all the bond violations that he's had while on bond, I don't have faith that he'll take it seriously.
I had to put it out.
I know, I understand, and I appreciate the tenacity, but the only true with the issues that we've had with him, yeah, let's do it.
Okay, Judge.
Okay, thanks, Mr. Gassano. Is this what you want to do? Are you sure? So you know, the thing that you have to understand is that DAs, the office, only has so much patience, right? When they see someone that's back and forth and back and forth, it's like a little child, right? We've told them once, we've told them twice, we've told them 3 times. You start accumulating things. At some point, this is not enough. And TDCJ in Huntsville becomes a new location and becomes a new possibility for you. You are, after today, there nearly on everything. I mean, with regard to either DWIs, with assaults, there comes an affirmative finding of family violence. If you ever pick up another assault like this again, you're looking at prison time, up to 10 years in prison. You understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. There is an affirmative finding of family violence, meaning that you can never own a gun or ammunition as a result of this plea. Should you pick up another assault like this, you'll be facing a 3rd-degree felony, up a minimum of 2 years, up to 10 years in prison. Do you understand? Is this what you want to do? Is it paper or is it electronic?
It's electronic.
Electronic? Oh, thanks. The agreement that you have worked out is 1 year to be probated for 1 year. This will go on your record. there is a TRAS that must be performed, which is an evaluation to see what conditions you need. If they assess conditions, you must fulfill them. No drugs, no alcohol, the batter's intervention prevention course, which is called the BIP class. You must attend this class once a week for 18 weeks. If you fail to go, then they're going to kick you out of the program. If we see that you have not complied with the conditions, we issue a warrant. I will put you back in jail. We will have a hearing to determine if you violated this agreement. If you do, you're looking at a year in jail. You understand? That means also no drugs, no alcohol, 24 hours of community service, and no contact with the complaining witness in this case. How do you plead to this offense? Guilty or not guilty? I'm not going to, well, I am going to find you guilty. However, I'm going to sentence you to a year, but I will probate it for 1 year. If you do everything that you promise us that you're going to do today, then you will steer clear out of jail. Are you working at this time? Okay, so waive his fees. No weapons as well. Did we already appoint him a lawyer for the other two cases?
Yes.
Okay. All right. Do you have any questions?
Yeah, but the community service, is there anything else I can do this optional condition also? Condition, no conditions.
Is it one?
Yes.
Is it as a result of this accident?
No.
Let's see if there's anything that he's able to do. If not, then we'll figure something out. Because there's got to be something else instead of, laborious that you can.
Judge, could he take an effective decision-making course and not run some of that community service out?
I don't know. Let's see how bad the condition is. And I have to figure that with all the things that we have here, he's probably already done multiple effective decision-making classes. And so I don't want to just keep doing redundant things and just for. All right, Mr. Guevara, good luck, sir. All right, we'll have you meet with Shatoria. Thank you, Mr. Metz. Ms. Childs, you're back.
Yes, Judge, I'm here on Miss Laisha Foxworth. She got done with felony court early, and I think she needs bond conditions on her misdemeanor cases.
Hold on, I couldn't hear anything. Say it again.
I'm here on Miss Laisha Foxworth. She needs bond conditions on her misdemeanor case.
Ms. Foxworth, come up. Good morning, ma'am.
Good morning.
Ma'am, you are charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. Did she just get here?
Felony. She checked in this morning and.
Oh, she has a felony on? Let's see what that is. So she's on probation for an aggravated assault, serious bodily injury, and now she's picked up a mischief. Same complaining witness?
Let me check. No.
What happened here, if you don't mind?
So here it looks like, it was in regard to an assault call that was later changed to a criminal mischief. That the defendant had caused damage at a dental office, due to receiving medical advice, but refused treatment. And then at that point, a computer monitor as well as, 2 office phones were broken by the defendant.
Got it. Ms. Foxworth, as a condition of your bond, you're ordered not to go back to this location and not to be in possession of any weapons and not to have any contact with the complaining witness. I want you to understand that I'm going to do everything in my power to protect my community. If you do anything to violate these conditions, you pick up a new case, I will go bananas on your bond. Do you understand me?
Yes, Your Honor.
So do you mind filing the no contact, no weapons, no going back? For now, I'm going to have you sign a receipt. We will have you take a seat in jury box while we get your bond conditions. It is your responsibility to stay in touch with counsel. If she tells you she cannot get a hold of you, then I will revoke your bond. You will not get any more PR bonds. If you pick up any new cases or you violate conditions, into jail you go, and I will deem you a public danger and I'm going to make your bond high. There are no mistakes in this life. There are choices. You either make a good choice or you make a bad choice. Do you understand?
Yes, Your Honor.
Come on. Stacy, do you know what day you want?
Yes, if I could have July 9th appearance waived, that would be fine. That's the day after her felony setting.
You don't want the same day as a felony?
We can have the same day too.
What, do you know what day that is?
She's about to.
July 8th.
July 8th.
Okay.
We'll set you the same day. That way you don't have to double up, you know?
Okay, thank you.
Yeah. Okay. Have fun.
Thank you.
Bye.